Okay, good afternoon, everybody. My name is Joseph Dickey. I'm a shareholder here at Hainsworth Singular Board, and welcome to our November employment law webinar. Today, we're talking about understanding employee free speech rights. There's been a lot of that going on here, especially turn of the year, but especially in this last quarter of the year. And it always gets confusing, so we thought we would kind of touch on it today. Before we get started, let's tell you a little bit about the firm. If you don't already know, we're a full service law firm with 115 plus attorneys and five office locations across North and South Carolina. I am in the Columbia office and part of the labor employment team. Um, Please feel free to ask questions. This is informal. I'm just happy that you decided to take your lunch hour to be with me. We might not go an hour, but I'm here to just kind of talk about this topic. If you got questions, shoot it in the chat or, however you need to get it there. And we'll have the slides sent to you after the presentation. Today, in talking about free speech, we got a couple of goals, and I do say goals. Hopefully we'll kind of talk about what is free speech. I know you should probably run into employees. They say, it's America. I can, free speech. I have my rights. But free speech can be limited in the employment context. So we'll talk about that. We're going to talk about the difference between public and private employment protections, look at federal and South Carolina laws that talk about free speech or that regulate free speech or speech in the workplace. We might touch on some political speech, social media, and National Labor Relations Act issues, which are going to be quite prevalent, especially for private employers. It doesn't just, impact unions. We'll have some probably brief touching on policy drafting and kind of looking at how do you address certain speech matters and, excuse me, talk about some cases that have occurred in South Carolina and Fourth Circuit. Excuse me. So with that, let's go into speech and the workplace. When you're in the workplace, HR, you have all kinds of things that can happen. I kind of spitball in here. You might have people talking about social media. You might have people have arguments over social media. People might like to have their, I guess, beliefs, political or otherwise, on social media. You might have people talking about the game at the water cooler or in the coffee room. People are just scrolling, whatever it is. There might be election day, the day after election day, whether it's local or otherwise, and people are just talking and doing all kinds of things. And some of those things might impact speech. It might impact what's going on at the office. It might cause disruptions. And so, if that is the case, how do you address it? What happens? Your challenge is to allow people to, be able to talk, be able to be free at work, to communicate with each other, have open discussions. But also, if there's, a political issue that might be causing a problem, or if there is a comment or something that is said, whether it be possibly outside of work, online, or internally, how do you address that as HR or as a leader in your company, in your organization, and not, get into legal trouble, not, expose the organization to any liability or any issue. So with that, let's talk about the First Amendment. Congress shall make no law respecting the establishment of religion or prohibiting the free exercise thereof or abridging the freedom of speech or of the press or the right of people peacefully to assemble and to petition the government for redress of grievances, i.e., we have free speech. And now, I know you have employees and people that say, I have free speech. I can say what I want, do what I want. To an extent, yes, but that does not mean you are free from consequences. And I think that's the important thing we need to understand here. And we need to make sure as we train our employees, as we are addressing things, if we have to take disciplinary matters, whether we're public employers or private employers, is that, we're not going to be, I guess, technically addressing somebody saying they don't have the right to do something. We are saying that you don't have the right to do that here. So, I kind of want to talk about myth and reality, and I kind of touched on it already. You'll see the classic case. Somebody posted something on Facebook, I guess Instagram, TikTok, whatever it is now, that about some belief they have. I hate red cars. They're awful. And let's say that's a particularly impactful statement that causes a stir in your organization and in the community. Well, their first response is, I have free speech. My employer can't fire me. I do what I want. Well, if you're a private employer, you're not bound by that First Amendment. Yeah, you can fire them, and you'll see later on there are cases that where there have been employees that have spoken out against certain things at work, but or they've spoken out online, and it's caused them to, you know, have some adverse employment consequences. However, you're public, you are bound by the First Amendment, and so you just have to really start looking at a test of what is this a matter of public concern? How is the person speaking? What's going on? Another reality we need to understand: while private employers are not bound by the First Amendment, there are restrictions under the law, usually federal, that can be National Labor Relations Act, and then let's not forget our discrimination statutes. You don't normally look at those as free speech implications, but there you can't make comments that are going to offend or create hostile work environments or be used as retaliation in violation of those federal statutes, such as you can't, if employees opposing a discriminatory practice, that's going to be in violation of Title VII. But that also is a speech matter. And so let's not forget that. And lastly, is one that people probably aren't aware of as much, excuse me, is the South Carolina Political Opinion Statute, which we'll talk about. That applies to private employers as well, state law. And it provides a public policy consideration that's outside the at-will employment doctrine, which prevents an employer from firing an employee for exercising political belief or political opinion outside of work. So as you get down to the key questions, when you're looking at a kind of issue, obviously you don't have to do the first question because you already know if you're a public or a private employer. But what was this? What happened? What was the content of the speech? And sometimes that means you got to look into more. What was the context? That's looking into your investigation. Then you're saying where, when did it occur? Off duty, online, with who? What was it about? And then you got to determine what laws are implicated, if any. And then that's when you come to a decision. And so these are key questions you should look at anytime you have that type of issue arise. Now we'll go to the next slide. I'm getting it's kind of redundant, and throughout this, you're going to see me being redundant. It's about employees don't have the free speech protections, First Amendment protections in the private sector. So we've talked about that. So let's talk about South Carolina law, the 1617-560, which I'm glad I have it on there. On that statute says that it is a crime to discharge a citizen from employment, i.e. terminate somebody because of their political opinions or the exercise of political rights and privileges guaranteed to every citizen. Person who violates this provision is guilty of a misdemeanor and may be fined not more than $1,000 and imprisoned not more than 2 years. So now that's very specific. You'll see cases. I think we have listed in here later on is Color versus Blue Ridge Electric. And there's some other cases as well. But these cases, not all of them are going in favor of the employee, but it's showing that people are using employees are using this statute very liberally to, bring claims because they are trying to say that this is their right, their opinion, if they are saying something online or otherwise. And something I didn't mention, I'm glad I'm looking at the slide. If you go down, third bullet, the South Carolina Human Affairs Law. Now, that's just the state statutes and regs codifying the Title VII and the federal discrimination statutes. These are also state laws that are going to impact speech because, again, you can't engage in any offensive, discriminatory speech or conduct that will, offend somebody in a protected class. So just remember those laws are on the books. That they can be brought through a shack charge, and sometimes people have tried to bring them in court. So just remember that the shack laws are still alive and well and will impact speech. All right, if you go to the next slide, we talked about these are the three categories, major categories for private employers that will impact your speech outside of the First Amendment. The biggest one is the National Labor Relations Act, Section 7. This talks about concerted activity. Concerted activity meaning if an employee is raising any issue or problem, concern, something that would impact the rest of their colleagues, the employment workforce as a whole, you can't restrict that speech. You can't prevent them from discussing. You can't retaliate against them as well. This is a very broad statute. It's been applied to the NLRA, and the courts have applied this to social media, and have applied to social media posts, and it's been applied to, simple emails or grievance requests that employees may make. This request, such as an employee might say, "Hey, I want to know about my pay going forward this year. I know that we've been receiving this," and then talk about their department. Well, while they were asking about themselves, because they started mentioning their whole department or their line level and talking about compensation, to an extent, it could be considered that they are engaging in concerted activities. So if there's any retaliation on that front, or if there's any, effort to chill that speech, that could be deemed a violation of the NLRA. That could be deemed as a action that the employer is trying to limit speech. Again, the EEO, the Equal Employment Opportunity protections about speaking out against discrimination, harassment, other unlawful practices. And then the last section is the whistleblower laws, whether that's safety, Sarbanes-Oxley, or other statutes. These are three main categories where private employers can be impacted by free speech considerations, or free speech limitations, rather. So with that, I know one of the questions we've had is looking at, how do the free speech protections or limitations or the issues impact public employers, private employers, or even getting into the nitty-gritty of it with public employers. And I'll try to take I think if I'm looking at my slides right, the public employers first. So if we go to the next slide. I have public employers listed on the left. Public employers must comply with the First Amendment. It applies to them. That's the government. And so, but your free speech protections, you don't have just this outright blanketed free speech protection because you work for the public government. But if you are speaking on a matter of public concern, then yes, you probably have a protection under the First Amendment. But there's a test that has to go that has to be applied to determine whether you are speaking on that matter of public concern. And there are cases that have been applied regarding that. And we'll get into that later. Lastly, the last bullet, social media posts about public issues possibly can be protected. That's similar to the labor relations issue in Section 7 I previously mentioned. It depends on how the person is speaking. There's a case that was recently decided, not in South Carolina or in our circuit, but I think it was in New York or somewhere, which I have listed in the slides that you'll get after the webinar, where fire chief or firefighter had two Facebook pages. One Facebook page was his regular, his normal profile. His other page said he was this public figure in some political party committee. In that page, he was the private page. He was making comments about, a particular group of people, and it did not go well. The community had caught backlash, but he worked for the city in New York, not New York City, but another city in New York State. And it caused a lot of backlash, and he ended up being terminated. Well, the court and the appeals court for that circuit ended up holding that his termination was fine. And that case turned on the fact that he wasn't speaking while he was speaking as a private citizen on his private Facebook page. He is the fire captain. He's a fire captain or fire chief, and he, as a as a matter of right, he was like a public figure for that city, and he also was speaking on a matter of public concern because of the nature of the comments he made was about a disenfranchised group of people that had prevalent issues in the area at the time, and so his termination was upheld. Just looking at the time, place, and manner restrictions on it, or the time and place and manner in which he made it. So those are kind of some issues. Looking at private employers again, I can't say it enough. No First Amendment limitations. Your biggest issue as a private employer is making sure you are not infringing upon the National Labor Relations Act. You're not restricting people from raising concerns about the group. You're not restricting people from engaging in the concerted activity. Not necessarily unionizing, but if you're bringing up issues that are going to be impactful or beneficial or concerning the group as a whole, you cannot take any actions to limit that speech. And obviously, you can't do anything to that would foster discrimination and retaliation. All right. Next page, Pickering versus Board of Education. For public employers, this is usually one of the more seminal cases when you're talking about your analysis of free speech. In Pickering, the Supreme Court discussed, said that the interest of an employee as a citizen commenting on matters of public concern must be balanced against the interest of the state as an employer in promoting the efficiency of the public services it performs to its employees. So again, we go back to public concern, as I mentioned earlier, and it's about just going back to the firefighter example I gave you, which if you start looking into these cases, there are a lot of firefighter examples. I don't know why. But what the court is saying that an employee for a public entity, for a government, for a municipality, let's say a special purpose district, what have you, if they are commenting on a matter of public concern as a citizen, fine. But you need to, if you're going to discipline, you need to determine whether or not this is going to be worth it. Does it make sense? Is it something, have they done something that's going to affect your operations before you decide to discipline them? Because they have that First Amendment protection. One example would be, say you take a police officer, and let's make a very heated example. What's going on now? Or you hear ice raids that are happening in the Southeast now, and you have a police officer who is working for a municipality. Let's say that police officer comes to a city council meeting, and he makes a comment at city council, voicing his opposition to lawful enforcement, should it be, assuming it is, of ICE raids or other immigration issues that are happening. And let's say that the city, the municipality, the next day terminates that officer. Does that create a First Amendment issue? Well, yeah, it creates a First Amendment issue, but where's the analysis? How do we look at that? Well, the first thing you look at, all right, he's a police officer. Was he at work that time? Yes, he was at work. Was he in uniform? Yes, he was in uniform. He came to the city council meeting on the clock and then spoke out against what was going on. So was he speaking as a citizen, as the Pickering analysis is talking about? I think I would say no, because he's on the clock. He has on his uniform. And so at that point, Do you stop your analysis? You could, but that wouldn't be prudent. So you would go further. Is it a matter of public concern? Probably. But he wasn't speaking as a citizen. And so you have that conflict, right? He's speaking as an agent, employee of the city, and he's speaking out against technically the city. And he did it publicly in his uniform. And if the municipality wanted to take discipline, I would be fine with advising you could take that discipline. Now, does that analysis change if he is just in the crowd? And he speaks and he's in private clothes, he's not on duty, and he says the same thing. Does the analysis change? Does the decision change? A little bit. And what it would turn on there is whether or not what position he was in the city. At least for me, it would as a lawyer. It would change on what position, whether he was chief, whether he was in leadership in the on the force or not. But if not, I would advise the municipality. Well, he spoke as a private citizen on a matter of public concern. You need to let that go. He has that protection. So let's go to the next slide, and voila, there's the analysis. So I will read it out because I think it's helpful to just have it articulated in a short form rather than me kind of just going through a scenario. But your first thing to look at if you're a public employer, if your employee has spoke out on something, made a comment that or engaged in some speech that has caused a ruckus or something, was the employee speaking as a citizen and not in his job duties? Just like the officer, which one was he? Step two, was the speech on a matter of public concern? It's one thing to talk about something that's going on in the community, whether that be, immigration, development, or something. It's another thing to talk about, the shoes we wear, as the law enforcement officers. I'd rather for us to get Nikes than Reeboks. Yeah, was it a matter of public concern? Step three, does the employee's speech interest outweigh the employer's interest in workplace efficiency, public trust and safety, i.e., does the free speech protection outweigh the government's interest in operating? That's a case-by-case decision. Step four, was the speech a substantial motivating factor in discipline, but for causation? Meaning, would you have taken this action but for the speech? Would you, if he didn't say that, would you have still taken action? If so, depending on what your other factors say, you might could still go forward with the employment action. So I hope that kind of helps with kind of any questions that have been, I guess, lingering or had beforehand regarding public employers. If you go to the next slide, it's still talking about public employers here. I kind of halfway went through it, but these are some of a non-exhaustive list of things that could be or have been considered matters of public concern. Allocation of school funds, bond issuances, bond referendums, people that testify before legislature, funding for emergency services. These are things that are matters of public concern. People might bring up as a citizen, or if they're working for a school district or a municipality, a special purpose district or whatever, they might bring up some of these things. This is not exhaustive by any means, but this just kind of gives you a flavor, gives you an idea of what can be brought up and what a court would deem as a matter of public concern, and puts you in the mind frame. If you're analyzing a situation, or if a situation comes up that you have to address, you can kind of use this as a reference. So we're going to transition to the state law cases under the political opinion case, the political opinion statute for wrongful termination, which again, this applies to private employers as well. Now, we all know that South Carolina is an at-will employment state. You can be hired and fired for no reason or any reason at all, but there are exceptions. Most of those are the federal law discrimination statutes, but you do have public policy exceptions, which are if the employer took any action, adverse action against you as an employee that violated a public policy of the state or i.e. a law of the state, then that could be considered a wrongful termination. And so you'll see now people will bring cases citing that section 16-17-560 has been violated in their termination. Excuse me. One of the cases, I think the one I want to point out is the Vanderhoff case. I think that's the second bullet point. In this case, I think Mr. Vanderhoff, I think he brought 2 lawsuits, if I'm not mistaken. And he identified himself as a different ethnic group, which was the Confederate Southern Gentlemen. And he brought Title VII and some other claims, but said that he was prevented from placing his Confederate flag decal on his toolbox. And that the company terminated him. The court dismissed it. So he brought the case again, and he brought it up under the state statute. Well, he again lost. The court said that Mr. Vanderhoff's, engagement of putting a Confederate flag decal on his toolbox was not political action, political opinion, or any other activity that would be covered under that statute, and so that the company had the right to terminate his employment. You've seen this come up. It comes up from time to time. I know that there have been within recent, I'd say 7 or 8 years, maybe this has come up in school setting, in public school districts as well as private schools, and it's been similarly addressed. Even in the private schools, similarly addressed. But these are things, and it's come up even on the here in recent years, especially since the pandemic, with people wearing Black Lives Matter paraphernalia and things of that nature. And so, the courts have been pretty consistent on this issue. But wanted to kind of give you, especially with the climate as it is now, kind of give you what was going on, how the court stood, and this was what, 2003? And it's been fairly consistent. Another one I wanted to bring up, though, is the last one. I believe it's Owens case. Now, this was applied to this was a private speech issue. And in Owens, I believe the employee worked for the defendant. And they did construction. Now there was a project that the defendant his employer had within this municipality. The employee I think he went to a meeting, or he was out in the community, and he was opposing the project. Now, obviously, you're opposing your employer's project as a member of the community, and so your employer has a financial stake in this. Well, the employer ended up terminating the employee, and he brought suit under this statute. And he said he was exercising his political opinion, and he was exercising his rights as a concerned citizen, all the things that we have talked about. Well, the court did not agree with him. They upheld his termination. Now, why? Well, what they found out is that the employee was actually using company resources, the copier, to assist him in opposing their own project. And so it was more than just the opposing of the project. He was using the actual company resources to assist him in his oppositional campaign. Now, let's take that same situation and say, all right, let's say Owens is working for the municipality. Let's say he's like a deputy administrator and he works for the municipality. No, let's change that. I'm sorry. Let's say he was in zoning. I'm not gonna make him administrator. Let's say he was in zoning. And let's say he is opposing this project that is coming into the municipality by the same company. And let's say that he's not using the city's resources to do it, and he's never wearing his city polo or anything else when he goes to community meetings or other activities that talk about the project. Can the city terminate him for doing it under this statute? No. Can they terminate him? Well, can they terminate him, period? I would say no. Does he have recourse if they did terminate him under this statute? No. I would say he does not have any recourse under this statute if he got terminated, but he would have recourse under the First Amendment because the city would have violated his First Amendment rights because he was speaking as a citizen about a matter of public concern, a big, large development investment coming into the town. And it meets the rest of the McVeigh and Pickering factors. So just wanted to bring that up because I found the Owens case very interesting, and I find that it is real good to talk about and distinguishing things. Before I go on, I want to see if there are any questions that anybody might have that I've missed or anything before I go on. And I'm gonna take a sip of my water. Okay, if not, we're going to turn to the National Labor Relations Act. I already defined the concerted activity part of Section 7 of the NLRA. But this has come up more and more over the years, whether it's be for speech or other conduct that happens with employee. I think if you look at the second bullet, this is a non-exhaustive list, but the concerted activity that employee can bring up in their speech could be their employee speech. Why can't we talk about, let's say, the president or the administration or the election? Or why can't we talk about working conditions, pay, time off, vacation time, discrimination? So you have to be careful about, how you, I guess, try to not only apply restrictions that you might have, but also how you draft the policy that you have maybe in your handbook, because even that can impact the free speech. But you're starting to see these cases come up, whether it be at the Labor Relations Board or you're seeing these cases come up in court. As far as, and you can go to the next page, but I'm not really going to talk about this slide. But what I really want to just talk about is, when you're trying to address some of these things with concerted effort, especially with the increased unionization attempts and goals that are going on now, I think it's important to kind of make sure as you're looking at your policies, all right, is this policy specific and talking about the compensation, or is it talking about safety and schedules? Does it provide, clear answers? Is it, if I'm saying that you cannot engage in, let's say, mischief, lewd, lascivious behavior or conduct or speech at work, I have that narrowed down and I'm using the specific words to say, so I'm not just saying, don't say anything rude, which is broad, overly broad. Is my social media policy very specific about what can get you in trouble, what cannot get you in trouble? And then do I have a clarifying provision or policy in my handbook or manual that makes sure everybody knows I'm still not trying to violate your Section 7 rights under the Labor Relations Act. Nothing in here should be considered that way, but I just want to have my policies out there for you. So I think, looking at that is what just from a policy standpoint, what you're going to look at under NLRA. As I look at the cases, it gets interesting. Just quickly, the first case is about Facebook likes and comments about tax withholdings. That literally was considered concerted activity. Um, I think that's interesting, but be mindful. Some you might have people that have engaged in text discussions on social media. Um, Lime, I don't think the GM case and the line, I can't even say the word, but I think the Facebook like case is the more interesting situation here because you do have comments that might come up in a employment context or employer context where an employee might make a post about something that happened at work, and then you see the rest of the employees jump on the post and start commenting, and they're commenting about the post, but in actuality, that post and comment is about an issue at work. And so for to know that the labor board, is taking that kind of interaction on social media and saying that it's concerted activity, um, we have to be mindful. And it's always good to keep our head about ourselves and always be prudent and have a plan, have our procedures in place of how we analyze not only these situations, but any kind of personnel situation before we act and take discipline or do any other action that might come back to haunt us. We need to be able to stand behind any decision we make. So it's always good to know, very technical issues like this one to kind of be mindful. Oh, that changed, or that's now being considered. Okay, we will govern ourselves accordingly. Going into this last slide of under this section, I want to kind of just remind you while we're talking about speech and the limits or the issues in free speech in the workplace. I have political affiliation up there about how that's not protected, but just know that in some of these, people might have free speech to talk about certain topics, whether that may be like I have there, religion, in the pandemic, they talk about medicine, COVID, how you handle that, LGBT conversation, whatever the case may be. And maybe those conversations aren't in violation of your policy per se, but those conversations, depending on how they go, how it sounds, frequency of it, who's around, could expose you or lead to other complaints that are discrimination. Um, you still have Fourth Circuit, exposure for hostile work environment of third parties if it's based on a protected class. There's the example I gave, my manager discriminates against Hispanic Americans because of his comments about Trump's executive orders on immigration. Well, that's a vague statement, but if you play that out and start getting specific examples, you could see, let's say you have for 6 months, you have employed a group of employees that stand, I guess, at the coffee bar that you might have at your office, and they have certain comments about certain policies or other issues, and you have a Hispanic Americans that work for you, or that are also employees in that same area, and they start to feel offended or they feel otherwise, limited in what they can say. You might have this speech issue that isn't technically an issue that you are having to address under your speech policies or otherwise, turn it into a discrimination issue. And so it's something to be mindful of, something to kind of just have your ear to the ground if you're in HR, and knowing what's going on to try to, prevent instead of reacting. Okay, we'll go to the next slide. So what to do? Addressing the speech in the workplace, which I'm kind of jumping around. I hope y'all bear with me because I'm just kind of one to address the topic. I think it's a complex topic with a lot of moving parts. Um, as an employer, you have the right to make sure you can operate, you can conduct your business. You have that right. And so whether it's the expression of political views, views of soda, or anything else, you have the right to make sure that If Joseph is sitting there ranting about Coca-Cola, as long as my rant about Coca-Cola is not affecting how HSB is running, I think we're all going to be fine. But you do have that right. But in doing so, you know, you just need to make sure you don't discriminate or otherwise violate somebody else's rights to talk. That said, if you're talking about political views, uh, you can have that a political discussion or the speech policy in your handbook if you want to. Some people do, some people don't. But if you're going to have it, um, my advice has always been to make it specific, have standards of conduct of what is not tolerated. But I would also, provide forums or avenues where employees can have those discussions if they so choose. If it's going to become something that is, frequently done, or is it something based on the climate? I think you grab it by the horn and take control of it, and where you can control the space of where the conversation is happening. That truly assists you as an employer and mitigates any exposure you might have from a free speech standpoint. Um, if you're going next page, if you're looking at other speech protections or other speech, I guess, avenues where you can try to address your free speech or mitigate any problems with your free speech or speech at the workplace. Be clear in your policy and talking about where prohibitions apply. Do the prohibitions apply to conduct off duty, including social media? Yeah, maybe. Yeah, I think you can write that in your policy. I'm working for HSB. I have a social media account. I'm writing crazy things on there. I think HSB can, talk to me about that because I am representing them. Don't see any legal issue with that. But social media is also the same place where you go right back to the first slide where people are talking about, well, I have the right, this is my personal account, I have free speech, First Amendment. So the best thing you do is have a very specific policy that kind of makes sure we know that, or the employee and where everything stands on it. That's where you get with counsel, and we can assist with that. And try to make sure we put you in the best situation as possible. And that's where next slide talks about your policy guidance. Strong enough to justify discipline, i.e., making sure we're all on the same page. Again, don't violate NLRA. Now, the third bullet point: must follow and enforce what you write. I can't stress that enough. Similar to the documenting activity. If we're gonna make it a policy, we need to follow it. We can't follow it, in January. We can't then say, you know what, February, I'm too busy to follow it. But you were wrong. So just know I sent you this email, you're wrong. And then come April when they do it again, and we're trying to figure out how do we address the problem. We can't do that. That gets us in trouble later on when we do have to finally take the action. So if we're going to put it in the policy, just make sure you're willing to follow it. And again, like I said later, be specific. Make sure everybody's on the same page. So I say on the slide, explain the difference between appropriate, whether it be political expression or inappropriate political expression, or appropriate speech or inappropriate speech. I don't think any problem with you explaining that and trying to distinguish it, or draw the line for employees. Employees need to know. The more that you're all on the same page and understanding the rules of the game, the better. You don't want to be playing football while your employees playing hockey. That's just recipe for disaster. Next slide is going to give you some good policy features, but also give you some policy pitfalls. I think I want to talk about the pitfalls. Don't have ambiguity in your policy. Oh, sorry. Ambiguity in your policy, i.e., don't say bad things. I think that's the easiest way to have a vague policy that I'm telling you to avoid. make sure you are meaning what you say, saying what you mean, and addressing the conduct you're trying to prevent. Um, don't have a very dictator-like social media policy, but it needs to be a clear, targeted social media policy that makes sure the employees understand, the rules and the policy and what you expect as an employer. You can't ban people from doing everything on social media just because they work for you. But you can have consequences for certain behavior that you may outline. Excuse me. And then lastly, just try to ensure your policies don't single out certain groups of people that might have certain viewpoints or certain groups. Sometimes that's unintentional, but just kind of audit your policies from time to time. If you have policies in place already, audit them and kind of look. Next slide. I think here we're talking about just common scenarios that may come up. Um, you got posts, and we've talked about a lot of these posts that employees might make. Posts might or people might talk about supervisors, management, uh, coaches, whatever the case may be. Uh, you got to look at your key questions that are on the right. This is about working conditions. Because if you're a private employee, you're looking at, all right, is this going to be an NLRA? Is this a Section 7 issue, a concerted activity? Does it connect to the work? Does it involve discrimination? When and where did it happen? All these questions are going to be pertinent for public and private employers. The NLRA concerted activity question is going to be as important as for the public employer because you have the First Amendment, the First Amendment protections or limitations, but all the questions are applicable. And so these are just certain questions you can always have as a starting point to if you have a situation that comes up. Your manager post, oh, I hate Joseph and how he does the schedule every day, and he just runs our crew ragged, and people keep commenting and liking the post. You discipline Joseph for doing that. Well, I think those questions come up at that point based on what we've learned today. We go to the next slide. This is kind of a duplicative slide, but it gives you some more best practices and things that I've kind of mentioned. The only thing I really haven't mentioned is involve counsel early when it's high profile, politically charged. But I would say involve counsel when you need to. Don't be afraid to call your lawyer, whether that's me or whoever. It's better to try to handle something on the front end than on the back end. If you have some doubts, go ahead and make your call. I'm looking at things. Yeah, I see documenting. So again, no matter what we're talking about on these employment law webinars, just know we're going to tell you to document. All right. Next slide. Here are some things that we've been looking at that are coming up. AI. As we all know, Skynet is coming alive, and so we need to be ready for it. AI is capturing communications, taking notes. Sometimes we don't know it. We don't know how that's going to continue to evolve. And so, what that might lead in a free speech situation, we're unsure. Or people working remotely, or things said in somebody's home office or at home. When does the test stop for when you're at work, when you're not? Looking at some risks. Looking at the NLRA and protect our EEO related compliance. If you're monitoring somebody or is the monitoring for AI if the AI monitoring is going to prevent people from having free discussion, is that a violation? Is that impacting speech? Yeah, I already said blurring lines on the remote for remote workers. Um, there are some complicated issues out there, and especially if they're if they're different states. So there's just a lot of issues that are emerging. Now I know we got 10 minutes left, so I don't want to kind of try to go through these cases, but I did provide them. There's some cases for you to look at once you get the PowerPoint. But I do want to go straight to the key takeaways so I can give you some time for Kate for some questions, if any. Um, Takeaways. All right. Your free speech protections at work are limited and context dependent, meaning it depends on, public, private employer status. That changes your analysis, but there is an analysis. Clear, yet neutral policies and consistent enforcement. Make sure everybody knows what game we're playing, what the playing field is. That's helpful. That's going to be a way to set yourself up for success. And so, if you're HR and leadership, and you want to make sure your team downstream is able to handle things, I think having regular training on it, on how they can impact or how they can address certain speech issues, regularly auditing or kind of reviewing your policies to make sure there's nothing that's going to get you in trouble, or trying to get them in the best situated position they can. And lastly, in South Carolina, just remember there is a political opinions statute that can get you into a wrongful termination case. We must remember that you cannot fire an employee, public or private, for outside of their political opinion. So with that, I hope this has been helpful. I hope that this PowerPoint will be helpful, at least as a reference point, if you need to pull out something quick to look at for if you have a speech issue. My contact information is on the screen, but are there any questions?
I don't see any, Joseph.
All right. If not, I've enjoyed it. Hope you have a great remainder of your day, and look forward to seeing you next time. Bye.
Thanks for joining this webinar presented by Hainsworth Sinkler Boyd. To learn more about the firm and its services, visit hsblawfirm.com.